Assalamualaikum warahmatullahi wabarakatuh. Today, our group will be presenting the topic of freedom of religion through the case of Fatimah binti Sihi and Ors versus Mio Atikur Rahman bin Isha and Ors on 2005. So, according to the facts of the case, it stemmed from the actions of three elementary school students whom wore serban as part of their school uniform. They were students of Sekolah Kebangsaan Serting Felda Bahau, Negeri Sembilan. So this matter took a worse turn when their guardians, Syed Ahmad, ignored all warnings and actions taken against him due to their refusal to not wear serban. So as a result, the students were expelled on 10 November 1997, 6 months after this issue began. The reason why this expulsion happened after all the warnings is because wearing serban or turban is prohibited by students according to Regulation 311 of the School Regulation 1997. This expulsion then was brought and challenged at court, with a learned judge ruled in their favor and cited this legislation as unconstitutional. The appeal to decide whether School Regulation 1997 is unconstitutional or not is what finally made this case.
Next, I will explain the issues in this case. The main issue in this case is whether the school regulation that bans students from wearing turban or serban during school hours violated Article 11, Sub-Article 1 of the Federal Constitution, which guarantees every person the right to profess and practice their religion. The first issue is whether wearing a turban by Muslim schoolboys can be considered a protected religious practice under Article 11, Sub-Article 1. The appellants agreed that wearing the turban was part of their religious practice and that the school rule prevented them to practicing their religion freely. The second issue is whether the school regulation was unconstitutional because it restricted the students' freedom of religion. The court had to determine whether the ban created a serious limitation on religious freedom or whether it was only a minor restriction that applied during school hours as part of the school uniform policy. The third issue is whether wearing a turban is an essential Islamic practice. The court needed to decide whether it was obligatory, integral, or merely encouraged in Islam, because the level of religious importance would affect the degree of constitutional protection. The final issue concerns the authority of the school to enforce uniform rules for discipline and order. The court had to balance the students' right to religious freedom against the school's responsibility to maintain discipline and uniformity among students.
My name is Nur Alin Nazifa Muhammad Kamarisham, and I will explain the judgment made by the Federal Court in the case of Fatimah binti Sihi and others versus Mio Atikur Rahman bin Isha and others. The Federal Court dismissed the appeal and held that the school regulations of 1997, which prohibited the wearing of the serban during school hours, were constitutional. The main issue before the court was whether this prohibition violated Article 11(1) of the Federal Constitution, which guaranteed the right to profess and practice religion. The appellants argue that wearing the serban formed part of Islamic religious practice and therefore should receive constitutional protection. However, the Federal Court rejected a broad interpretation that every religious practice automatically receives constitutional protection. The court also rejected the strict integral part of religion test used previously because it could create an all or nothing result. Instead, the Federal Court introduced a multi-factor balancing approach. First, the court considered the importance of religious practice, meaning whether it is mandatory or merely encouraged in the religion. Second, the court considered the extent of the restriction, whether it was a total ban or only temporary or partial. Third, the court looked at the surrounding circumstances, including school discipline, uniformity, and national unity. After considering these factors, the court decided that wearing a serban for schoolboys was not an essential religious obligation, since the restriction was only limited during school hours and was considered reasonable. The court held that Article 11(1) had not been violated. Moving on to the principle of law applied in this case. The decision mainly involved Article 11(1) of the Federal Constitution, which protects the right to profess and practice religion, and the Article 11(5), which allows restriction for reasons such as public order, health, and also morality. The court rejected the appellant's argument that Article 11(5) was the only limitation that could be imposed on religious freedom. The court also disagreed with the rigid integral part of religion test because it was considered too restrictive and unable to deal with practical situations effectively. Instead, the federal court developed a multi-factor balancing test. Before they apply the balancing factors, the court first looked at threshold requirements such as whether a religion exists, whether a practice exists, and whether the practice genuinely belongs to that religion. Then the court considered balancing factors like the importance of the practice, whether it is wajib or sunat, the extent of restriction, and the surrounding circumstances. The court also relied on supporting authorities and previous legal principles to strengthen its reasoning. This approach allowed the court to balance constitutional rights with public interest rather than giving an absolute answer.
In comparison with other related cases, especially Fatima binti Sihi and Ors versus Mio Atikur Rahman bin Ishaq and Ors, the court also dealt with issues concerning freedom of religion. The Court of Appeal applied the integral part of religion test, which is used to determine whether a religious practice is essential and therefore protected under the Constitution. This test was based on several Indian cases as well as the Malaysian case Hajah Halimatus Sa'diah binti Haji Kamaruddin versus Public Services Commission Malaysia. However, the federal court later clarified that this test should not be the only factor in deciding such cases. Besides determining whether the practice is essential, the court also considered the importance of the religious practice, the seriousness of restriction, and the school environment. Overall, this shows that although the freedom of religion is protected, it can still be reasonably restricted if the religious practice is not essential and the limitation imposed is minor.
Through Islamic perspective, the Islamic ruling used in this case depends on the public interest concept, which is maslahah mursala, and the legal categorization of religious acts, which also called as al-ahkam al-khamsah. Wearing a serban or turban is not wajib in Islam, or even mandatory, but rather a sunnah jibliyah, which is a commendable and praiseworthy practice by Prophet Muhammad that also reflects his culture. Hence, prohibiting admirable but optional clothing in public settings does not compromise the core principles of Islam or even violate the fundamental religious mandates.
To conclude, this case demonstrates that the constitutional right to practice religion under Article 11(1) is not absolute and may be subject to reasonable restriction. The Federal Court applied a multi-factor balancing approach by considering the importance of the religious practice, the extent of the restriction, and the surrounding circumstances. The decision shows that the court attempted to balance individual religion right with broader societal interests such as school discipline, public welfare, and institutional harmony. Therefore, the case highlights the importance of maintaining both constitutional protection and practical social consideration. I think that's all from us. Thank you so much.